Hello, 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 mic testing. Hello, 1 2 3 4. Hello, hello.
চাপ্লিখন দিছে ন
Morning. Yes. You are for the petitioner? Have you? Uh, Why have you not informed the other side earlier? Anyway, let this matter be called up. I have some junior, there are enough juniors of Dr. Saraf. Ensure someone is in the court. Yes. It's a 2019 matter, mister. Wait for the matter to be called. Whoever is assisting Dr. Saraf should be in court. You please inform. Yes. Next. The 15 matter, please wait for your turn. Don't make mention of these old matters. Wait for the matters to be called up. As far as possible, this court will accommodate you, but let us open the file and see why these matters have been listed. They are matters of 2015, 2014, will not be adjourned merely for the asking. Yes. Listing of which bench? Pertaining to which bench? Bench 4. Senior bench is there, mentioned before the appropriate bench. Bail. You must be attentive while the mentioning is going on. I have just said to make a mention before the appropriate bench. Yes. The part third matter. Verify corridor. All right. When do you want it? Thursday. Subject to verification. Yes, call the list.
Supplementary list, item number 23. Daily list, item number 1.
Earlier rejected by this court. Yes, updated CD. Updated call for updated CD list on 16. Next.
Item number 2.
All right, same order.
Item number 3.
Okay. 15. All right, in item 3, 407 420. Where is the FIR? This why is this second AB? Where is the rejection order? Only 50 boxes was recovered. All right, you have the updated CD, Mr. Parashar. Next week. All right. Next week. Next week. Give a date. Updated CD and 17. Next.
Item number 4.
Yes, Mr. Barbuya. 366. Okay. Call for the updated CD along with the statement of the victim recorded under 164 CRPC. List on 21st.
Item number 5.
354C. Okay, Parashar, updated CD. This is wrongly listed. There is one bail application 780 which appears this court has disposed. Maybe because of that. Call for CD list on 17.
Item number 6.
Yes. But why before this court? This is that who are you? This is the first time you have approached. You are one of the member. Right, he is a member, Mr. Parashar. Let him appear. The interim. Yes, okay. Heard Mr. S. Rana, Learned Counsel for the petitioner. Also heard Mr. K. Parashar, Learned APP for the state respondent. This is an application under section 438 CRPC for granting pre-arrest bail to the petitioner I. Mubarak Hussain, who is apprehending arrest in connection with Hatigaon PS case number 38/2024, registered under section 120B, 420, 421, 422, 423, 386, 387, 34 IPC. Stop. The case of the prosecution is that on 28/2/2024, an FIR was lodged inter alia alleging that as per information, an institution, namely Soraighat Trading and Cooperative Society Limited, where an illegal office for lending money to different people of the locality as well as others at high rate of interest by taking mortgage of valuable property were going on. Stop. It is the further case of the prosecution that after the information received, the jurisdictional OC had directed the complainant to proceed to the above mentioned spot, and upon reaching there, a search was conducted at the office of the cooperative society, and the secretary of the society was arrested. Stop. Accordingly, a case has been registered. Stop. Mr. Rana submits that the petitioner is a member of the cooperative society and the cooperative society lends money to its members in terms of the bylaws adopted. Correct? Stop. Call for CD fixing on 22nd 5/2024. Stop. Considering the facts and circumstances of the case, it is provided that in the event of arrest of the petitioner named above, in connection with the aforesaid case, he shall be released on interim pre-arrest bail on furnishing bail bond of rupees 20,000 to the satisfaction of the arresting authority, subject, of course, to the following conditions. Number 1, 10 days appearance. 2 and 3, list accordingly.
Item number 7.
(307-302). This is rejected earlier. You have? Why is this listed before this court? Earlier, this court has dealt with a similar affair.
21.
Okay. All right, then perhaps CD would be required here. When can you produce it? Call for CD, list on 16. All right.
Number 8.
Yes, Mr. Abdullah. Offence is under 307-302. Call for CD, list on Monday. Sixteen, okay.
For admission. Number 9.
Yes. Verify and type the affidavit. Yes, government. You've received. All right, then when can we have it? MS Udas, learned additional senior government advocate, submits that the affidavit in terms of the order dated 27/3/2024 has been filed today Stop. Mr. So and so learned counsel for the petitioner submits that a copy has been served upon his junior few minutes back. Stop. Let the registry verify and place the affidavit on record. List this matter on 14. List this matter on 14/5/2024. That I have already indicated.
Item number 10.
Passover? Time being. Okay. Passover for time being. Whenever both parties are there, matter will be called. Alright, Mr. Gogoi and Mr. Bhattakur?
Item number 11.
Alright. MS Udas, learned additional senior government advocate, submits that after conducting survey of the subject land, instructions in the matter has been received. Stop. She accordingly seeks time for placing the same by way of an affidavit. Prayer is not opposed. List this matter. Yes, when? After 2 weeks on a date to be fixed by the registry.
Supplementary list. Item number 21 and 22.
My lord, I have received the instruction. Last occasion, my lord, the Honorable Court directed me to get written instruction, my lord. I have received it, my lord.
You have received. Mrs. Hazarika, let her place it by way of an affidavit. Any urgency?
On the in urgency in the sense that I purchased this land. Now I can't get it mutated in my name. I can't use it. That's the
Next
problem.
week, my lord.
Next, because
File it positively, Ms. Das, by
Madam.
next week.
No, my lord.
MS Yudas, learned additional senior government advocate, submits that the necessary instructions has been received by her office in the matter, and accordingly seeks time to place the same by way of an affidavit. Stop. Considering the urgency canvassed by MS M. Hajorika, learned senior counsel, assisted by
Yes, Lord.
MS so and so for the petitioner, comma, a last chance is given to the respondent to file the affidavit within a period of 1 week from today. Stop. List this matter after, give a date after 1 week.
My lord, 21st of 22nd, after 1 week.
22nd is difficult, Lordship. Why
Give
you
a
can
date.
find
Give a date.
17th, Lordship.
17th, Ms. Das?
16th, 7th Friday.
Today is, my lord, Thursday, next Thursday. My
You
lord,
have
1
already
week, Lord.
received the
My
instructions.
lord,
Weekend is coming. You can always draft it. All right, 22nd is difficult.
Lordship 20.
Give a date after 20.
my lord.
Lordship 24th in that case.
My lord,
24.
deeply obliged, my lord.
21 and 22, Mrs. Hajorika. Both.
Yes, both.
Same, similar, my lord.
All right.
Bail hearing. Item number 12.
Application, Lordship.
Yes.
For 38 application, my lord, the petitioner before your lordship man is
PD
not
available?
not in name in the FIR, my lord. He is on interim, my lord, and appear before the IO as per the direction of this honorable court, and his statements has already been recorded, my lord.
Why is
Allegation
this
against
before this court?
my lord.
Why is this AB before this court?
My lord, the apprehension, my lord, summon has been issued.
No, why before this court?
My lord, lordship has granted the interim bail, my lord.
That is, I don't think in that situation it is required to be listed before this court.
2-3 occasion, my lord.
One,
matter come up.
Torun,
Mr. Parashar, if I, Rupak have notification, because only if it's correct. In that case, because otherwise,
or earlier rejected.
this is not the regular bench
Regular bench.
dealing with these matters. This matter will have to be listed before the regular bench then.
Yes.
It will not be
rejected
proper
by
for this
Lordship
bench to. Correct, right?
Yes, my lord.
It appeared, right? It appears that this AB has been wrongly listed before this bench. Stop. Let registry to verify and list it before the appropriate bench tomorrow,
After some day, my lord.
Sunday,
Monday, Tuesday, Monday,
on so and so date.
Monday.
Then, or you say next week on a date to be fixed by the registry. Let registry fix the date.
Continue.
Same order passed earlier shall continue till then.
For hearing, item number 13.
May please, your lordship. I am for the respondent. This matter may be kindly possible for the day.
This is a part heard matter.
Our party is already over.
Yes. Mr. Dasgupta is appearing this matter.
Yes, yes, sir. He lags in court number 1.
When do you want it?
Next week.
On behalf of Mr. A. Dasgupta, learned senior advocate, appearing on behalf of the respondent, comma, MS B. Das, seeks some accommodation in the matter. Stop. Considering the difficulty canvassed on behalf of the respondent, comma, this matter is posted on. When do you want it? Next Thursday date to be given. On such and such date for further hearing.
16. Item number 14 and 15.
Yes, what is this matter?
Hello, this is regarding the non-payment of the compensation amount. to the claimant, I mean, whose land was acquired, I mean, whose land was acquired way back in 1969.
Land acquired in 1969. Until now, compensation not given.
On the last occasion, this honorable court had directed the district commissioner to submit a report regarding whether the payment has actually been made or not.
Yes, any payment made? Any report from the district commissioner?
My lord,
Yes, Ms. Das?
My lord, I have filed affidavit, but regarding the last order, my lord, probably, my lord, I need
Mr. Jogen Handik was there, my lord, he was specifically handling this matter.
But I don't find any such.
Find any, my lord, later also.
No, but even I do not find that part in the order. Which order are you referring to?
The last occasion, my lord.
Order dated?
It is a order to assume.
এটা আছে last one to nine
It appears from the last instruction which was placed by the government advocate, this land in question has been converted into a government land.
Yes, ma'am.
Correct.
After acquisition.
You are right. Accordingly, J. Handik was directed
Yes.
to clarify the matter.
My lord, we can wait for some time and till my
Ms.
handicap
Das,
is-
you obtain instruction in terms of the order dated 14/3/24 that will bring clarity to the matter,
my lord,
because it appears that that is the only question which is left open as whether the petitioners whose land admittedly has been acquired has been adequately compensated or not.
Not.
Correct.
My
Now,
lord.
if it is not done, then it has to be done.
But
Cannot keep the petitioner hanging
sure,
since
lordship,
69.
true, my lord,
Correct.
true,
So,
my
Ms. Das, you take positive instructions.
My lord.
You can give us a firm date by which you can get
lord,
these instructions.
this is from
In fact,
Kamrup.
instruction will not do better. You file an affidavit,
affidavit, my lord.
because then the petitioner will also know what is going on.
That case, my lord, I pray for my lord.
Anyway,
2 weeks, my lord.
you check a date. But
My
let
lord,
me
2 weeks, my
dictate till then. Paragraph Likhiba. MS U Das, learned additional senior government advocate, takes 2 weeks time to obtain instruction in terms of the order dated 14/3/24 passed earlier by this court. Stop. Prayer is not opposed. Next para. Since the only question which falls for determination in this writ petition is whether the land acquisition compensation has been paid to the petitioner, comma, the instructions sought for by this court by order dated 14/3/2024 is essential to dispose of the writ petition. Stop. Accordingly, 2 weeks time is granted to the state government to positively file their affidavit in this regard by the next date. Stop. List on
2 weeks, my lord.
My lord,
22nd, my lord.
the first week of June, my lord.
My lord, I'll be happy, my lord.
First
date
week of
Dijak.
5th of June.
14 and 15.
Item number 16.
Lordship, I am appearing for the private respondent.
Where is the respondent? Sorry, petitioner.
Lordship. On the last occasion also, they were not present,
Is it?
and on the last day, they prayed for time. The previous day before,
It is not recorded in the order sheet.
Lordship.
What is this matter?
Matters regarding the award, Lordship, the management, the petitioner management has challenged the award passed by the London Labour Court in reference number 15 of 08 Lordship will find the awarded page, Lordship, in the petition. Page 18, Lordship. It's just a page 18.
Page
18, 1
Sorry, Lordship, I have an instruction that since the Assam Textile has been taken over by the AIDC, the matter will be taken up by AIDC Council. So they want some adjustment for today, Lordship, since because they are busy in some election duty and all.
So there is some development as regards who will take up the brief on behalf of the petitioner.
Lordship. Yes, Lordship. Previously, G. Chaudhary was handling, but
Your name?
MN Konyak.
MS
MN Konyak.
so and so learned counsel for the petitioner submits that since the petitioner corporation, i.e. Messrs. Assam State Textile Corporation Limited, has been taken over by
AIDC.
AIDC,
yes.
There has been change in the arguing counsel.
Yes.
Stop. Accordingly, she seeks some accommodation in the matter.
Yes.
Prayer is not opposed by the respondent side. List this matter after 2 weeks. Or give a date. It's a 14
Lordship,
matter.
for 14 matter, Lordship.
Date.
27th May.
List this matter for further hearing. Not further hearing. List this matter on 27/5/2024 for hearing. Stop. Needless to clarify that by the next date, the council, the standing council, there is a standing council.
Yes, there will be.
By the
some
next
standing
date, the standing council AIDC shall be ready to do the hearing in the matter, considering that the matter pertains to the year 2014.
Lordship, only one thing may I pray. This prayer was made on the last occasion also, but that was not recorded.
Correct.
Only thing may I pray that they may be directed to inform the council for the AIDC. Otherwise,
I've already said needless to clarify.
They have communicated the letters also to us.
You have communicated.
They have also communicated to us
Saying what?
regarding the since the matter has been taken over.
Have you
now,
handed over the
yes,
file to them?
They haven't come yet, Lordship. We have informed them. They haven't come to collect due
You
to
add
elections.
one more line. It is further made clear that that MS so and so learned counsel for the petitioner shall hand over the records of the writ petition to the standing council AIDC within a period of 2 days from today. Stop. You hand it over, get a signature, and you keep it.
Yes.
Produce it on the next date.
Item number 17.
Lordship, in this matter, some up-to-date instructions are awaited from the department, Lordship. Lordship may kindly give
Last
1
time
week.
also a similar prayer was made for respondent number 2.
General election, Lordship, we could not seek instructions, Lordship. Lordship may just grant 1
You
week
have
time.
to appreciate that this matter is of 2015.
Lordship may just grant 1 week time,
What
Lordship.
instruction you want?
Lordship, the up-to-date instruction, Lordship.
MS G. Bora.
MS B. Chetri appearing on behalf of MS R. Bora.
What is your name?
B. Chetri, Lordship.
MS B. Chetri, learned counsel for respondent number 2.
1 and 2, Lordship.
Respondent number 1 and 2 submits that the up-to-date instructions which were required to be furnished in the matter in terms of the order passed earlier, due to the ongoing election, the same could not be submitted. Stop. She accordingly seeks further
1 week time, Lordship.
1 week time to furnish the same. Stop. Prayer is not opposed by the petitioner. Stop. List this matter and a date did you after 1 week.
16.
Is it okay?
Okay.
On 16/5/2024.
Obliged, Lordship.
Item number 18.
If you want your names to be recorded, then just give an appearance slip.
Please, Your Lordship, the matter may be passed for time being.
Time being.
Time being.
Time being. Yes.
Item number 19.
I am appearing on behalf of Highway Authority of India. National Highway Authority of India.
Jirat compensation.
Here, my lord, they are for Jirat compensation. They are not entitled less because this is damages caused beyond right of way. That is beyond our acquisition land. But however, last occasion I have submitted before Lordship that number of cases are like that the contractor has damaged this one. Though we are not entitled for, their demand was from various NGOs and from these areas. Our Union of Minister also settled the matter. That is why they are trying to settle the matter to get something. But otherwise they are not entitled. If petition,
so there is some possibility of some
possibility
settlement.
Because their possibilities discussion is going today morning also.
Then perhaps I can adjourn
No,
this matter.
here matter was the last occasion I requested him because that committee is one committee is constituted particularly for this to discuss these issues. This one. Then I have because we are not knowing who our names are there. This is with the government. Thereafter, last occasion I have submitted before Lordship. Now also morning I inquired from the office, concerned office. No list has come to us. Then I requested him. Then in the meantime, you also file an application because NGO is there, something committee is there. You also apply because their names may not be there. But I don't know whether maybe adjourn for today because
no representation today.
Yeah, that is why my lord maybe adjourn for 2 weeks.
19, right?
Right, my lord.
None appears for the petitioner when the matter is called. Stop. Mr. C. Burwa, Learned Standing Council, NHAI, submits that though the petitioner is not entitled for the Jirat compensation in view of the fact that
this Jirat compensation because that is damages caused beyond right of way. That is ROW.
In view of the fact that the damage has been caused
by the contractor,
beyond
ROW, right
of way.
My lord, that is why.
However, he fairly submits that there has been an
some committees,
there has
one
been
committee
a committee
is
constituted to explore
the possibility, my lord.
The possibility of settlement
My lord.
in the matter.
For similar type of
Similarly
persons.
situated
Persons.
persons. In case of
Affected
similarly
persons.
situated affected persons.
My lord.
Stop. Be that as it may, comma, since there is no representation on behalf of the petitioner today when the matter is called, comma, list this matter after.
Only one observation, that will not affect, that will help for both of us. Liberty is granted, though it is not there, liberty is granted, let them approach the authority concerned.
List on after a week.
After a week, my lord.
21, 524, stop. Then you write, needless to clarify, comma, that the petitioner
may also
is at liberty to approach before the
that
concerned committee and submit its representation before the committee for consideration thereof. Stop. As and when such representation is filed before the concerned committee, comma, the same pendency of this writ petition shall not be a bar for the said committee to consider the same in accordance with law.
All right, sir. It may help them.
Item number 20.
Yes.
Well, this is a matter pertaining to the interpretation of the BIS, Bureau of Indian Standards Act 2016.
You are for the respondent.
Respondent number 7.
This is the matter where there was a mentioning. In the morning. Yes.
My only difficulty is, Malad, I would have not objected to an adjournment, Malad. That's something that I never do. Lordship will just see this note, Malad. Courtmaster sir, if you can hand it over. Malad, time and again, Malad, dates have been taken in this for some reason or the other. I'm not. Written submissions have been filed, Malad. Matter has been. There are orders, Malad.
These adjournments were on behalf of the petitioner.
Malad, not a single time on my behalf, Malad. I have been present from Delhi on each and every of the occasions, Malad. That is my difficulty. And the matter is absolutely, Malats, with greatest of respect, I shouldn't say it in the absence of my learned friend on the other side. It's, Malats, completely frivolous, Malats. And I will demonstrate that in just 2 minutes, Malats. What I say, Malats, they have challenged.
It is very unfortunate that despite this court having made it very clear that
somebody should
have been there, no one is there.
Well,
it is very unfortunate because besides the person who was making a mention, there are other resisting counsels' names which is reflected in the cause list.
Several one of them.
Yes. How do the court proceed when such, this is the conduct of the bar. It's a whole matter.
And
merely because of asking adjournment cannot be granted. It is the prerogative of the court to grant or not to grant, isn't it?
Absolutely.
Now the difficulty is you are there, but if petitioner is not there, how do we proceed?
Correct.
Yes, what were you saying?
I will then argue and assist your lordships only to arguments which are not prejudicial to that, only on the interpretation of the Act and what the Act says.
Mr. Gogoi, you are there in this matter. Can you send a message to one of the juniors of Dr. Sharaf? There is Mr. P. Borwa, Mr. Jed Islam, they were there yesterday also, N.N. Datta is also there.
We'll keep it that for a while, or maybe in the meantime, Malad, may I just assist your lordships? Malad, my primary argument as far as this petition is concerned, and I'll just say that in 3 sentences. 1, they themselves in the petition say that the notification has not come into effect and it is only a recommendation. Para 3 and several other players, I'll point it out. Second point, Malad, they themselves say whether to put BIS or not, Malad, in a particular...
What is otherwise in challenge in this petition?
Malad, they are challenging, Malad, the government of India, Malad, they wanted, and the Bureau of Indian Standards, Malad, BIS as it's called, they wanted to affix a standardization mark like ISA used to be earlier, which is now BIS, Bureau of Indian Standard, on phenol, Malad.
On phenyl.
On phenyl, Malad. Phenol, not phenyl. Phenol. Now, Malad, they say that I use phenol as a byproduct in the plyboards that I manufacture, and therefore I am affected, Malad. They are not the importers. They have nothing to do otherwise with phenol, and that is again one of my other submissions, Malad. Now they are challenging a notification where it is proposed that BIS would be imposed, and it is not imposed, mind you, and that is exactly my preliminary objection is, Malad. Can a writ petition be maintained, Malad, against a recommendation which has not come into effect?
Against the apprehension.
Absolutely, Malad. I'll show 3 paragraphs if your lordships don't mind, Malad. Lordships will come.
You are for?
I am for an intervener, Malad. Respond number 7, at whose behest, Malad, I am a domestic manufacturer. Malad, I manufacture phenol, Malad.
You have been allowed to intervene?
I have been allowed to intervene, Malad, and I am only going to state only such arguments which are there in the pleadings of the other respondents.
Your otherwise role in this matter?
It is, Malad, I am the domestic manufacturer as far as phenol is concerned. Based on Government of India guidelines, I set up with huge investments, Malad, various quality standards, Malad, as far as my factory is concerned, so as to enhance the quality of phenol so that it doesn't impact the environment. What the petitioner's clients are doing, Malad, or not the clients, the importers are doing, they are importing non-Malad quality, the standardized phenol into India, as a result of which the whole Malad system is being polluted. First. Secondly, Malad, it actually leads to an unfair advantage of the importers Kuami, Malad. So that is my objection, and it is at my representation that the BIS was supposed to be sought to be imposed as far as phenol is concerned, Malad. That's my role. Malad, I have been part of each and every meeting of the core committee. Malad, they have also been present. I have also been present, Malad. There is no dispute as far as that is concerned, Malad. Now, Malad, may kindly see para 3 of the petition, Malad. Lordships will see.
Yes.
Lordships will find that at page 6. Lordship has that?
Yes.
That in the instant writ application, the petitioners are challenging the validity and legality of the recommendations of the respondent number 1 apparently taken during the course of the expert committee meeting held on or about 22/4/2019. Lordships will then come to para 7. Para 7 at page 13.
Yes.
That your petitioners state that the impugned recommendation of respondent number 1 to bring 2 imported industrial raw materials, namely phenol and melamine, amongst others, is perverse in colorable exercise of power vested in the respondents for collateral purposes without satisfying the prerequisites under the BIS Act. Malords, when the notification has not come in, Malords, can you challenge it? That's the first point, Malords. I'm not going, there are several other pleadings, Malords, I'm not going to that. Second point, they themselves admit, Malords, it is a policy decision. Your Lordships will see page 159.
Mr. Gogoi, could you inform? 100?
159.
The 159?
159.
Yes.
This is a representation, my lord. Your lordship sees the page before that, that is 158. This is
15
sent
July 19.
Correct. 15 July. This is
a representation filed by?
Filed by them, my lord.
Petitioner?
Yes, petitioner, my lords. Century Plyboard, your lordships will see a division of Century Plyboard remitted at the letterhead, my lords, at the top of the page. Lordships will now come to 159.
Just 1 second.
Yes, ma'am. I'm so sorry.
Yes.
Yes, ma'am.
Page 100?
59. It starts at 158. It is a representation given by the petitioners to the ministry, my lords, as to why the certification should not be done. 159, second paragraph. Lordship has the paragraph which starts with, it is necessary to clarify. Yes. It is necessary to clarify that FIPPI is an accredited Federation of Panel Products Industry in India by the Ministry of Commerce, GOI, New Delhi, and should have been consulted on the important policy decision. Now, whether BI, they themselves say, my lords, that it is a policy decision. My lords, what remains, my lords, and I am directly covered, my lords, by a judgment of the Gujarat High Court, my lords, Justice Pardiwala's judgment, exactly on the point and on BIS, my lords, exactly on the point. That whether to impose BIS or not, my lords, is a clear policy decision. And the court in a rich jurisdiction, my lords, should not interfere, my lords. Lordships will see straight away, my lords.
Piyush, in the meantime, you please find out when Dr. Saraf can address this court in this matter. We are hearing the other side, so otherwise this court is going ahead with the hearing. Either as it may, this court will give you a short accommodation. So either on Monday or Tuesday, when it will be convenient. In the meantime, you have that information with you, right? And also you take note of the submissions that is being made, right? But I don't see your name. Your name is there in the...
Lordship, my name is there, but I don't have any instruction, Lordship. All the assisting counsels of Dr. Saraf, Lordship, unfortunately or fortunately, there is a wedding of one of his juniors. Everybody
Whatever, but you see, it is not a case where there is only one person, right? There are so many juniors. When a matter, that too of 2019 is listed before the court, some
I understand, Lordship.
some duty the bar also owes to the court, right?
Lordship.
So at least you are there. So you take the instructions, you coordinate with them, and you give us a date when he can address this court. In the meantime, also take note of the arguments. I don't want this hearing to otherwise remain as an unnecessary formality. So therefore, you take note of it.
We've also handed them a copy of our written submissions already, my lords. Lordship has a judgment, para 1. I'll just read quickly the facts. By way of this writ application under Article 226 of the Constitution of India, the petitioner engaged in the business of computer printers, etc., seeks to challenge the economics and information technology...
Electronics and information
technology good requirements for compulsory registration order 2012 dated 7 September 2012. Pursuant thereto by the central government in exercise of powers conferred under section 10(1) small p of the BIS Act 1986 as it was then, read with Rule 13 so-and-so of the Bureau of Indian Standard Rules 87, being ultra-virus unconstitutional and violative of Article 19(1)g of the Constitution of India, the case made out by the petitioner is summarized as under. Malas, may I just put a small caveat? My case on facts is much better than this, because as far as this case is concerned, Malas, there was a notification under the...
there is an apprehension.
Absolutely. I'm so grateful. Lordships will thereafter, Malas, come to para, Malas, findings start at para 22, and may I have the liberty to read from para 28 onwards, Malas. From para 22 it starts, I'll read from para 25.
Yes.
From the above, it appears, Lordship has that paragraph.
Yes.
From the above, it appears that the central government in its wisdom thought it fit to evolve a policy with a view to safeguard the interest of consumers. It has been clarified that the impugned order is applicable only to the manufacturer of electronics and information technology goods, irrespective of their nationality. The manufacturer who is desirous to market and sell its products in India is obligated to get the electronics and information technology goods registered with the respondent number 2, that is the BIS, who would conduct the test in the laboratory recognized by the respondent number 2. In such circumstances, if the goods are imported, are also subjected to such test with a view to see that it adheres to the standards prescribed in India, then it could not be said that such an action or decision is violative of Article 19(1).
Can you read this para once again?
Yes, my lords. 25. Yes. From the above, it appears that the central government, in its wisdom, thought fit to evolve a policy with a view to safeguard the interest of the consumers. It has been clarified that the impugned order is applicable only to the manufacturer of electronics and information technology goods, irrespective of their nationality. The manufacturer who is desirous to market and sell its products in India is obligated to get the electronics and information technology goods registered with the respondent number 2, that is the BIS, who would conduct a test in the laboratory recognized by the respondent number 2. In such circumstances...
All right.
Yeah.
So it is basically to ensure that the standards are
maintained. And as far as India is concerned, a particular standardized product comes into India, primarily for two, and especially for a product like phenol, because it is known as a hazardous substance. All
right.
Right. Para 26. It appears from the material on record that the laboratories authorized by the respondent number 2, BIS, demand for the purpose of testing. Let me skip this, and come to para 28.
In our opinion.
In our opinion. The notification restricting the sale from 3rd of July onwards of the products which are not registered with the BIS department in the interest of the people at large, because if something goes wrong, then nobody would be held responsible for the same, and in the process...
What is their grievance against, even if this notification is introduced, what is their grievance?
It's very high-flowery and high-sounding language, that's exactly the petition. They are saying, the fact, if you impose, then it will go against the trade barriers regulations, as far as the international treaties, etc. are concerned. I don't understand that argument, I have gone through this matter several times, at least that argument is beyond my comprehension as to how the trade barriers, the manufacturers of phenol don't have a problem. The government of India do not have a problem. Nobody has.
Manufacturer of phenol?
I am in the Indian manufacturer, the manufacturers who actually send the goods into India, They have not come before your lordships, my
And
lords.
this is a plywood
He is
manufacturer.
a user of that manufacturer, my lord. He uses those products.
He's otherwise a manufacturer of plywood.
Plyboard, my lord. He uses phenol as a raw material and he applies that. My lord, his quality of his product, he's a consumer. The quality of his products and the standardization of his products will improve.
If he's a consumer, what grievance can he have?
I am so grateful, my lord. To my lord's mind, there cannot be none.
You will have to meet your locus. What is your grievance? Because as it appears, I am yet to hear the petitioner side at length, but prima facie it appears that you are a consumer of phenol. Now the notification, which has not yet even come, which you apprehend may come, you have challenged it. How is this affecting a consumer? It is in your interest this notification, the BIS standards would be required.
I'm so grateful. That's exactly the point.
Anyway, this is what prima facie this court have understood. So I'm making it clear to you so that in this regard you are prepared on the next date. Yes.
I was reading para 28, my lords.
28.
In our opinion, 28, para 28. In our opinion, the notification restricting the sale from 3rd of July onwards of the products which are not registered with the BIS department in the interest of the people at large, because if something goes wrong, then nobody would be held responsible for the same, and in the process, innocent consumer will suffer. We are also not impressed by the submission that the second-hand computers are sold only after due testing, upgrading, reworking and refurbishing, which amounts to manufacturing activities according to Section 2F of the Central Excise Act. The order impugn mandates that such testing should be done by laboratories authorized by respondent number 2, BIS. It is not the case where the parallel imports are completely stopped or banned, but are permitted to certain restrictions, like submitting the products for testing to the BIS recognized labs to comply with the 2012 order. Exactly the case. There is no restriction, therefore there is no trade barrier, like it is being contended by my learned friend. My lords, a lot of para 30, many suggestions have been given by the petitioner in this regard, but we are afraid as of it is not for this court to consider such suggestions and then direct the government to look into the same. The court is not an expert in the field of electronics and information technology, and therefore should not ordinarily interfere with such decisions taken by the government. The duty of the court is to confine itself to the question of legality. Its concern should be whether the decision-making authority exceeds its powers. In this case, this is not applicable, no decision taken. 2, committed an error of law, committed a breach of the rules of natural justice, reached a decision which no reasonable person would have reached, abused his powers. The decision to impose BIS on this have been taken after consulting several stakeholders, including them. Their representation is on record. Next, Malad.
From which page you can show that they were present?
Oh yes, my lords, of course.
Just give me the page.
I will, my lords, I will. Lordships will see. Lordships will just give me a moment. Lordships will just give me a moment. Lordships will see. Well, let me kindly see page 158 itself. That's the same letter which I read.
Mr. Sharma, page?
Page 158.
158.
Yes. That's the same letter that I had read to your Lordships, my lords.
Yes, I have that in front of me.
Yes. Lordships, right at the beginning, Lordships will see the subject, your recommendation to bring phenol so-and-so under mandatory so-and-so. Pursuant to the decision taken by the expert committee meeting date under your chairmanship, your department has recommended BIS on so-and-so. Apparently, the move by your department to bring the above two goods, so-and-so, are in the exercise of powers under the BIS Act and the TBT Treaty. Trade Barriers Treaty, my lord, that is the TBT. We have access to the note so-and-so in which there is a so-and-so. Lordships will see the federation, last paragraph, is constituted by the several associations of plyboard mills throughout India, who are major stakeholders, being the single largest consumer, so and so, so and so. My lords may kindly see where their presence is shown.
It is not very clear.
Yes, my lord, I completely agree, my lords. My lord, there is a minutes, my lords, where their presence is shown. Lordships will see that. I'm just taking that out, my lords. Page 94. Page 94, Annexure 2C.
94.
Yes. In 94, where is their name? 94, that's the minutes of the meeting.
Yes.
And my lords may kindly see. 1 minute. Just Lordships will just give me a moment. Lordships will see serial number 20 in that at page 97. All India Plyboard Manufacturers Association.
Serial number?
Serial number 20.
Yes.
And my lords, the petitioners are member of that association, my lords. The Lordships will see list of participants also. Participants is enclosed. That is there, my lords. Lordships will thereafter see page 99. The representation that I showed was also considered, my lord. The representative of...
is the
Correct. Page 99 deals with phenol, my lords. And the para 2 of that, my lords, the representation of Federation of Indian Plyboard and Panel Industry stated that WTO TBT agreement...
Where Mr. Sharma?
My lords, page 99, small Roman 3.
Yes.
And the para 2 of that, my lords.
Yes, I've got it.
The representation of Federation of Indian Plyboard and Panel Industry stated that WTO TBT agreement states that the technical regulations should not be formulated to create obstacles to international trade. Before formulating technical regulation risk assessment regarding impurities present in phenol, scientific and technical information may be collected and taken into consideration. Without risk assessment, powers under Section 16 of the BIS Act need not be exercised by the Government of India. Further, he mentioned that the domestic industry of phenol is already protected from other countries by way of levy of anti-dumping duty. If further restrictions are imposed on phenol, their members may start importing phenol resins directly or substitute the material with pure resin. So this is exactly the argument in the writ petition, Malats, which has been considered. And they themselves say whether to impose or not to impose is a decision that is to be taken by an expert body, and it is scientific and technical in nature. Can a writ code go into it, Malats? Is again the question that I ask myself, Malats. Then, Malats, we have shown this letter. Give me the 2-page note. The 2-page note. Malats, besides, Malats, I had made a small book. This was actually for me, Malats. A pointer note. May I just hand it over, Malats? Lordship sees that. But before I take your Lordships through all these points, there is a summary of my written submissions, Malats. This was technically made for my convenience.
Written submissions is there?
It's already there on record. Malats, there is another judgment. Recent judgment, Malats,
you
January.
are respondent 6?
7.
Rupak.
Malats, may kindly see the judgment of the. Written submissions to us and my final sign.
Yes, Mr. Sharma.
Yes, Malats, may kindly see the Karnataka High Court judgment before I come into the short note, Malats.
Yes, which
it's a single judgment. Paragraph, Lordships will start from facts nature. Directly to the legal proposition. Yes. Malats, may kindly see para 13.
Paragraph?
13, at internal page 18, Malats.
Yes.
The notification impugned seeks to achieve a seal of BIS in every raw material that is brought in to the manufacture of a final product. The BIS, as observed herein above, is a national standards body which permits the development, standardization and quality certification of goods, and the certification will be through BIS standard mark. If this is sought to be achieved by the Union of India through the notification as a policy decision, this court exercising its jurisdiction
This is,
of course, that's the law, Malad. That's the law. So it reiterates.
So in this Karnataka decision, you are only relying on para 13 or
Para
any other
13,
paragraph?
14, para 13, 14, 15, 16, 16, 17 and 18.
All right.
And Malad, quickly to take your lordships through that note. So Malad, I have firstly laid down.
written arguments with my phone. Written arguments this time.
Malad, I'll just take a printout also in case it's not there.
Let him verify.
Yes.
And the Gujarat decision which you had relied,
yes,
there the paragraphs were
Malad, I will just tell the paragraphs
22
again. Malad.
and 25.
22, Malad, lordships will see from para 1, which is, lordships will see the actual finding is in para 28 and 29 and 30, 31.
28 to 31.
28 to 31.
And one more paragraph you had, I thought,
Malad,
relied.
that is para 25.
No, para 17 or 18, anything you have relied? No.
Malad, 22 I mentioned is where the findings start.
Right.
So 25, Malad, 26, 28 to 31.
All right.
Right, Malad. So quickly to take your lordships through the short points, Malad.
Achha, your written arguments are there.
Are
It
there.
is actually
Lovely.
kept separately. Now,
so, Malad, I had encapsulated initially, Malad, how the BIS Act works, Malad, probably.
so these standards, manual, everything, these are submitted by you.
Couple of them, yes, Malad, a couple of them have been submitted by the
Petitioners' written arguments are also on record.
All submissions are complete, Malad. And it has been exchanged amongst parties.
Yes, please.
Yes, Manoj. Look, I had given a broad background in the note as to how the BIS Act works, Malaj, and its basic foundation. I've already stated that. The next point that I had raised, Malaj, was that the writ petition is premature, Malaj, in view of various admissions in the writ petition itself, Malaj. I have also demonstrated from page 159, Malaj, that they themselves admit before the central government that it is a policy decision. Now, there is no dispute that phenol is a hazardous substance, Malaj, and therefore, Malaj, public interest demands that a standardization should be there in terms of that, and that is the rationale as to why in that notification, which is supposed to be...
Notification is into, if at all is going to be issued, it is going to be in the larger public interest.
Public interest to protect environment is what the notification, the draft notification says rather. Then, they have not challenged the virus of the BIS Act. Therefore, in the absence of any challenge to the virus, Malaj, that's my point E. Then point F, that this is an issue that is to be determined by scientific and expert bodies, Malaj. Then G is the point that your lordships had put it to them, Malaj. They are not the manufacturers. What is their cause as far as this is concerned, Malaj? Then, Malaj, no discrimination of arbitrariness is mentioned, Malaj. Then the recommendations, Malaj, I will demonstrate. The WTO permits this, and today, Malaj,
WTO means?
The World Trade Organization, Malaj, and today, based on
and this, by relying on Article 2.1b
of the Trade Barriers Treaty, Malaj, TBT.
Can you ask your junior to give these full forms?
I will make a small compilation. Can I email that to the courtmaster,
yes,
Malaj?
Yes.
I will do that. And Malaj?
So in point I,
yes.
Can you enlighten point I?
I will also, what I will do.
What do you want to say in point I?
Malaj, point I, there are enough leeways that are given under the TBT agreement to member countries, that's like India, to expand their scope and determine things to be done in their own jurisdictions. Based on that power, Malaj, India has imposed, Malaj, BIS standardized on more than 150 products throughout, Malaj, and after the, Malaj, only because of the order, interim order passed in this court, Malaj, this product has been excluded as far as BIS
So the
registration.
proposed action is as per the recommendation of the WTO guidelines.
Yes, my lord, it meets that standard, my lords. And my lords, their basis, they have laid down certain questions of law that emanates out, and that is all saying that it violates the TBT, my lords. There is no challenge to the Act. Trade Barriers Treaty. That is an agreement. That's a WTO agreement, my lords. That is their case, my lord. I'm so grateful. And I'll also put in a note, if your lordship wants, on these aspects in slightly more detail, my lords.
But, because otherwise, till G, there is no difficulty. But
correct.
I and they
I,
are
my lords,
probably a little more.
correct. So what I will do for A, basic scheme of the Act.
Right.
As also I will lay down 2 notes, my lords, and I'll hand it over.
Right.
Very well. I'm so grateful.
Yes, Mr. Gogoi, you want to submit or you want to wait till Dr. Saraf?
I can submit also. Even the GTT also.
Yes.
That I indicate.
Here you are appearing as for the central government. CG? Your designation is CG? CGC. Yes.
Before going to my affidavit.
Just one second, Mr. Gogoi. ডাঙৰ carrier. ডাঙৰ point. Yes, please.
Lordship, sir, the BIS Act, Lordship. BIS Act.
PI? এই এখন আছে নে আমাৰ? You have a copy?
I have it in my iPad. Can I give that?
এটা copy উলিয়াইও ল'ব.
Just I today just point out some legal point, Lordship. Otherwise, my argument will be, Lordship, I'll be.
Yes, what section you want to rely?
My Lord, may kindly peruse section 9. Section 9 is the powers and function of the Bureau, Lordship. Section 9.
Yes.
May kindly come to subsection 2, Lordship.
Yes.
The Bureau shall take all necessary steps for promotion, monitoring and management of the quality of goods, articles, processes, systems and services as may be necessary to protect the interest of the consumers and various other stakeholders which may be included the following, Lordship.
Quality.
Lordship. That is the statutory power, Lordship. On the basis of that was done. Then again, my Lord, may kindly come to section 13, Lordship.
Yes.
13 is, Lordship, in respect of the grants of license or certificate in conformity. That was also there a procedure, Lordship. Then, my Lord, may 16.
13 is grant.
Lordship. 16. Yes,
16 is the procedure.
Lordship.
Yes.
And 16, Lordship, under that particular statutory provisions that was done by the authority, Lordship. Even the notification should be issued. 16, Lordship. Central government to direct compulsory use of standard mark, Lordship.
That's the most important provision.
Even, Lordship, if we have issued a notification on the basis of recommendation, then it should be done under that particular statutory provision, Lordship. And
So
that
this
was,
BIS mark is a standard mark.
Lordship. And that particular provision was not put to silence before this honorable court. And it's a statutory power given to the central government. Under that particular vested power, the government has exercised its power, Lordship.
Yes.
Then, Lordship, make section 25, 16, Lordship, I will.
Could you read it out?
16. If the central government is the opinion that, Lordship, got it?
Yes.
If the central government is the opinion that it is necessary or expedient so to do in the public interest for the protection of human, animal or plant health, safety of the environment or prevention of unfair trade practices and national security, it may after
Consulting the Bureau.
Lordship, by an order published in the official gazette, notify a goods or article of any scheduled industry, process, systems or service. Next, B, Lordship, essential requirement to which such goods, article, process, system or service which shall conform to the standard
And direct the use of the
Lordship.
standard mark.
Standard mark under the license or certificate of conformity as compulsory of such goods, article, process, systems or service.
So your submission is that this is in terms of the
Lordship.
statute.
That proposed was
The
as per the
statute itself mandates.
It's still a mandate, is a statutory prescription under which the government has to exercise. Then section 25, 25(3).
25(3).
3. It's a chapter 5 miscellaneous. 25(3).
Yes.
The central government may take such other action as may be necessary for the promotion, monitoring and management of quality of goods, article, process, systems and services, and to protect in the interest of consumers and various other stakeholders, and notify any other goods, articles, process, system and service for the purposes in
action for quality.
Quality as per section 16(1). That is the statutory prescription under which the government has to exercise its power.
Alright.
And then even the petitioner's case is that it is barred by the GATT. GATT also give the permission to the particular country, member country, to adopt a policy for safety measures. Lordship. So Lordship may kindly come to the petition page 2 to 3.
To detail arrow. Page
2 to 3. It's a part of the Annexure 5. It starts from page 182. It starts from page 182, Lordship. The General Agreement of Tariffs and Trade. 182.
Yes.
GATT, Lordship.
Yes, yes.
It's a GATT, Lordship. And then my Lord may kindly come to page 2 to 3. Page 2 to 3.
Yes.
Article 20, Lordship. It's a general exception, Lordship. 2 to 3, Lordship.
Just a second, Mr.
Lordship. Lordship.
This is called the Agreement on Tariffs.
Lordship, and GATT, Lordship. GATT, Lordship. The General Agreement of Tariffs and Trade, Lordship.
Yes.
The TBT has been issued under the original GATT agreement, 19.
Here also, Lordship, Article 20.
I think your note has to
I will highlight
elaborate on those
I will
parts.
make a chart on I have understood what is falling from your note.
Article 20, Lordship. It's a general exception, Lordship. Subject to requirement that such measures are not applied in a manner which should constitute a means of arbitrary or unjustifiable discrimination between countries where the same conditions prevail, or a distinguished restrictions on international trade. Nothing in this agreement shall be construed to prevent, my Lord may kindly mark it, construed to prevent the adoption or enforcement by any contracting party measures. My Lord may kindly mark B, necessary to protect human, animal, plant life or health, Lordship. We have done as per the procedure laid down by the GTT also, Lordship. The proposed amendment, the proposed notification, that was also as per the GTT. It is not a case that the member country India has violated the Lordship international trade. There is no conflict with it, Lordship. Then my Lord may kindly come to page 285 of the GTT, Lordship. It's Article 2 of Technical Regulation and Standards, Lordship. Page 285.
Yes, this is also part of the
Part
same
of the
agreement.
GTT, Lordship.
Yes. Technical regulation.
Regulation and Standards, Article 2. So my Lord may directly come to 2.2.
Yes.
Members shall ensure that technical regulations are not prepared, adopted or applied with a view to or with the effect of creating unnecessary obstacles to international trade. For the purposes, technical regulations shall not be more trade restrictive than necessary to fulfill the legitimate object. Taking into account the risks of non-fulfillment will create. Such legitimate objectives are inter alia national security. My Lord may kindly mark that part. National security requirements, the preventive and deceptive practices, protection of human health or safety animals or plain life or health of the environment.
The environment, yes.
Lordship. Then Lordship kindly come to page 289. Just I am point out the relevant.
Yes.
289 is a, before that my lord may kindly come to page 288. It's article 5, conformity with technical regulation and standards, Lordship.
Yes.
To page 288.
Yeah,
Article
289,
5.
yes.
Now 289, Lordship.
Clause?
Clause 5.4.
Yes.
In cases where a positive assurance is required to products conform with technical regulations or standards, and relevant guides or recommendations issued by the international standards bodies exist, or their completion of imminent, members shall ensure that the central government bodies use them or the relevant parts of them as the basis of their conformity assessment procedures, except where, as duly explained upon request, such guides and recommendations or relevant parts of inappropriate for the member concerned, or entirely as such reasons, national security, my lord may kindly mark it. National security requirements to prevent deceptive practices, protection of human health and safety, animal, plant or health, or the environment, fundamental climate or other geographical factors, fundamental technological or infrastructural problems. Lordship.
Right.
The power was, even GTT also given that power, Lordship. It's not a case that the Union of India has violated the provision of GTT, and the act which proposed to be done as per the statutory prescription, Lordship, and that was not put to silence before the Honorable Court, as well as the condition and exception which was given in the particular articles of the GTT also not silenced before this Honorable Court. And the particular petition is a premature one, and in the light of the statutory provisions and provisions prescribed by the GTT, that writ petition should be dismissed, Lordship.
All right.
The legal issues just I point out. Other part, Lordship, what our affidavit says, I will, Lordship, deliver that on
Affidavits
that,
have been filed.
on that particular day, Lordship. Oblige, Lordship. And Lordship, some few judgments is also there, Lordship. Lordship, I mean, I can place this
Yes,
today also.
you have all the time.
Lordship. My brother has already
Is not your brother,
already
Mr.
placed 2-3
Gogoi?
judgment, Lordship, and I also placed.
Brother, Mr. Gogoi. Friend. That side it is friend.
Hello. Lordship.
There are a lot of pleadings, it appears from the index. But relevant would be which one? The affidavit in opposition filed on behalf of 123?
120 is relevant. We have
That
already.
is on 14/12/2020?
Yes. Well, they filed thereafter an additional affidavit, my lords, whereby they have sought to
Additional affidavit which is filed on 28/6/2022.
Yes, my lords.
So why I'm asking this, because unnecessarily, I don't want, if it is not relevant, so you may indicate which are the affidavits which has some relevance.
Well, what they have done, my lord, and again, my learned friend is not there on the side, my lord. What they have done in that additional affidavit, they have completely changed track. Initially, they were challenging, and they have not amended the prayer smartly, my lord.
But they have changed the
Entire
tone.
contour. Yes, my lord, exactly, and which cannot be done in my respectful submission. They have tried to, my lord, when you don't have a good case.
Which is that additional affidavit filed by the petitioner?
Yes, my lord. And we have all filed the report.
That I think is on 11/5/2022.
11/5/2022. Yes.
Alright, because otherwise it appears to be 765, the entire pleading.
Correct.
It would be unnecessarily if they are not relevant, so you can just indicate.
And also, my lords, the BIS.
This is your affidavit, Mr.
My lords,
Sharma.
my affidavit, your lordships will find, is at page
R7, no?
12/4/2022.
20?
22. 12/4/2022. Your lordships will take it.
Your affidavit is not here, looks like.
A minute.
What?
I will have it checked, my lord.
Just check, because it is not indicating R7.
My lord, it has a registration
Okay,
number
okay.
2528 of
No,
12.
there 5?
528 dated 12/4/2022. I have a stamp here, my lord.
There is an affidavit in reply filed by the petitioner.
Yes, my lord. No, my lord. No, that is thereafter.
There is one affidavit in reply by intervener.
That is mine.
25/4/2022.
25. There is 2012/4.
Anyway, you can verify this.
I will verify.
Please,
I'll have a file. I'll mark the flag, put the flags in that. And also, my lords, the BIS Act and the rules is part of the writ petition itself. So I will. Annexure 27.
Page.
Annexure 27.
Page.
Page, my lords. Your lordship.
Mr. Gugu, you are relying on this
Lordship,
decision?
just that.
2021.
2021 ASCC 511.
On what point?
Lordship, regarding policy decision.
Policy decision.
Policy decision.
305. I'm so sorry.
305.
305 is the BIS Act and 322 is the rules.
322.
Is the
All right.
Regarding policy decision, Lordship, here from paragraph 59 to 77. The Honorable Apex Court has, Lordship,
Paragraph
by
50.
this 59 to 77.
All right.
Just I point out only from the Lordship head note one paragraph, Lordship. From the
Why head note?
From the head note, Lordship, one paragraph. Functions of the court. Just
Mr. Gugu, this court doesn't rely on head notes. You want?
Then
You can go to
50
paragraph 59.
59 to 77.
Yes. It has basically referred to all the other
All
decisions.
the earlier judgment and finally Honorable Court says that it is not the function of the court to also interfere with the policy decision of the state, Lordship.
All right.
Paragraph 77, Lordship, may kindly for a moment.
Yes, with the limited scope.
With the limited scope of judicial review on the policy decision affecting the economy and or it might have financial implication on the economy of the country, the relief and submission stated herein above are required to be considered. Whether there shall be a waiver of interest during the that COVID period, there is some situation is there, Lordship.
All right.
But all the decisions are already discussed above, Lordship. Earlier decisions are discussed above in the 3 judgment, Lordship.
Okay.
Then, Lordship, other 2-3 judgment is there, Lordship. One is 2015 9 SCC 657. 2015 9 SCC 657, Lordship.
2015 9 SSC
657, Lordship.
657 and
Here, Lordship, I am relying paragraph 14 to 23, Lordship.
14 to?
14 to 23, Lordship. Okay. 14 to 23.
Policy decision?
Policy decision regarding.
Another decision you
Another is, Lordship, 2007 4 SCC 77, Lordship. 77. Okay. Paragraph 16, Lordship. 16. Paragraph 16. And another one is, Lordship, 2001 3
Same
SCC.
point. You need to multiply.
Lordship.
Then law, the limitations are well settled.
That 2021 ASCC 511, Lordship, all the judgments are discussed, Lordship.
Okay.
Yes. Okay, I have noted down, Lordship, and the instruction I have taken, Lordship, for the date, Lordship, if convenient to learned friends, 28th of May.
28th
of May.
That will be too late.
Lordship, because in the meantime, Lordship,
He was mentioning Tuesday, my lord. I am okay on Tuesday.
Lordship, Tuesday, Lordship, there is an Agartala matter, I have been told. Lordship will fix it on a hearing day, then Lordship, there is a holiday.
See, that 27 onwards, this code will not be available here and it becomes difficult. So you have it before it. There are 2 weeks. So in the next 2 weeks, you choose a date.
I'll just check.
Because it becomes difficult to keep these matters pending. This court has heard today, everything is fresh.
Karnataka and the Gujarat High Court are directly on the BIS Act, my lord, and the Karnataka deals with all the law as far as the subject is concerned.
Lordship, in that case, on 21st, Lordship.
All right. Mr. P. Sharma, Learned Counsel for the respondent number 7. Senior Counsel.
Not as yet, Manoj.
And Mr. K. Gogoi, Learned C. CGC has completed their part of the argument. Stop. List this matter on 21/5/2024 for arguments of the petitioner side. Part heard.
So grateful, Manoj. It's been a pleasure, Manoj, to appear before your lordship.
Likewise. State will go.
Standing item number 23.
I'm extremely sorry, my lord.
No problem, Mr. Goswami. Yes, this is that LPG matter.
My lord, let me make myself clear, my lord.
Just 1 second, please. এই মাত্র যোনটো হৈ গ'ল 20 আছিল ন? Yes.
It will appear that we have challenged this NIT, my lord, after having taken part in it, my lord. But I'll place the facts before your lordship, my lord. Now, my lord, we are a group of, my lord, transporters, my lord. Essentially, we carry, my lord, these gas cylinders in our trucks. There are different sizes.
In your trucks?
We are truck owners. We carry those cylinders from the NRL depot to, my lord, different places, my lord, in the 7 states, and then we get back with the empty cylinders. That is what we do, and for that we get paid, my lord, on kilometer to kilometer basis.
Now the petitioner is an association.
Yes, we are association.
Yes.
Now, my lord, as it is, my lord, depending on the, my lord, market inputs and, my lord, various other issues regarding, my lord, cost of transporting, my lord, these rates get revised from time to time, my lord. They get amended, they get corrected, my lord. For example, my lord, prior to, my lord, introduction of, my lord, toll tax, the rates were as it is. When toll tax came, my lord, that was also incorporated, my lord, the amount of toll tax that we have to pay in coming out of the NRL depot and getting into it. That is just one issue I am paying.
Toll tax.
Yeah, toll tax, one issue.
And there was some representation which
representation essentially dealing to, my lord, correction of
that was not disposed of.
Rates, my lord. Not disposed of, my lord.
Pending.
And we had come, my lord. Yes, still pending, my lord. And we had come prior to this occasion, my lord. We had come by filing another petition, my lord. In that case, nothing was decided on merit. Again, my lord, rates only, my lord. Correction of rates, my lord.
Here also, what is that you are seeking?
My lord, as of now, we are seeking, my lord, that rates be, my lord, corrected. Number one, my lord. I am making a very general statement.
No, because you have already participated in
we
the
have
tender.
participated in it. Then, my lord.
After participation, what correction of rates are you seeking?
Exactly, my lord. I'm coming to that. My lord, what had happened, my lord, earlier we filed a writ petition, my lord, and then writ petition decided that your representation has been answered. So that matter stood closed. So thereafter, my lord, we filed appeal under the provision of the NIT, my lord, before those 3-member committee, my lord, placing our grievances, my lord. Now, those have not yet been, my lord, decided or responded to, my lord, except one gentleman, my lord, who had said, I am no longer in the committee, my lord, so therefore I am not there, my lord. So we had also submitted a representative before the those have remained unanswered till date, my lord. Now, what has happened, my lord, during pendency of this writ petition, there was an interim order in the earlier writ petition, my lord. That financial bid will not be opened. Not exactly in these words, man. It was there, given in the writ petition. So that remained, my lord, like that, pending for quite a long time, my lord. Now, after, till we filed the representation after, my lord, closure of the writ petition, till then, also, my lord, they were not decided, my lord. During the pendency of the representation, my lord, they have issued on my lord 4th Saturday, no? Huh? Oh, on 4th of this month, my lord, they have issued LOI.
Report. Yeah, I got.
LOI, letter of intent to the.
When LOI?
On 4th month, Saturday.
4/12.
4th of May, man.
4/5.
Yes, ma'am.
Around 9 p.m. Yes.
At 9 p.m. in the night, man, in the evening. Next was a holiday, Sunday, then Monday, then again election day. For many of the transporters, this side, man, that is another holiday. And so 3 days have gone like that. I understood some of the transporters have accepted it on my lord, protest, my lord, without prejudice to their rights flowing from the litigation, my lord. Now, what has happened in the meantime, my lord? There is a provision in the NIT, my lord. Your lordship will kindly come to page
Just
111. It starts.
Question, Mr. Goswami. In this matter, notice was already issued.
My lord.
In this matter, notice was issued.
Yes. They were supposed to file affidavit. They have not filed. And matter was fixed for.
Notice was also issued on the prayer for interior.
Yes.
That is how today you are.
My lord, position.
You are arguing on the interior.
My lord.
On that basis. Now, in the interim, what are you seeking? Stay of the LOI.
My lord, stay of the LOI.
On what basis?
My lord.
Because you yourself had participated in
Exactly,
that tender.
Exactly.
Now, after being unsuccessful, you are putting that to challenge. This is
No,
one way of.
no, my lord.
By the association.
My lord, because many of our.
You are the association.
Association, and many of our members have been issued, my lord, they have got this thing, my lord. They have been issued LOI. They have issued LOI.
You see, in that situation, again, now the question will be that members, a few members of the association who's a petitioner, in respect of whom LOI has already been issued, then what is the grievance of the association?
My lord, only
it's
one
too
thing,
late now,
only
Mr.
one
Goswami.
thing, my lord, in my humble understanding, my lord, what has remained in this writ petition is one, my lord. For that, your lordship has to, my lord, I'll take your lordship to page.
What you are saying may be correct. Maybe the rise in the rates are arbitrary, but you see, these are things which has to be ultimately decided
Must be addressed by
after
them,
a
madam.
full-fledged hearing.
Yes, ma'am.
A full-fledged hearing
Yes,
will be
ma'am.
required. Today, this court is only concerned of the interim
Consideration
prayer.
of interim
Correct.
prayer.
Now, considering the fact, I'm sorry, I'm cutting you short, Mr. Goswami. I will give you enough time because it seems that this court has a lot of time today. So, no worries, this court will hear you. But in view of the fact that the members of the association had participated in the tender, not objected, the association at that time did not object, and after everything is done, this
association, what we have been doing, our representations are not individual representations. This is from the association side only, all along, man. This is not that some people have come and some have not, man. It's a collective.
This rate is this clause 14C.
14C is the issue, my lord. 115.
So, in your interim prayer, come to your interim prayer at page 31.
Your lordship will
Please to
kindly.
stay, suspend the operation of impugn tender 4830 in view of the rates becoming invalid as per clause
Yes,
14C.
that is the only issue that has remained.
What do you mean by the rate has become invalid?
Your lordship will kindly come to page 115.
115.
Otherwise, my lord, I don't think there is issues that at this stage, my lord, to address.
Yes.
Page 115, my lord. This is a part of the NIT, my lord.
Yes.
At the bottom of that page, validity period of rates.
So there is a validity period.
Yes, ma'am. Rates offered shall be valid and binding on the tenderer for 180 days.
Yes.
That means 6 months, my lord. From the closing date of the tender or from the date of the last negotiations, if any.
Yes.
Whichever is later, unless extended by mutual consent.
Yes.
In writing. During the validity period, the tenderer will not be allowed either to withdraw or revise his offer or on his own. This is understood, my lord.
Yes.
Breach of this provision will entail forfeiture of the earnest money deposit. Now, my lord, second part is, although directed, my lord.
This means that when when the bidder offers his rate, the
Rate has to remain firm for 180 days.
for 180 days.
180 days.
Unless mutually extended.
Yes, my lord. Now, in this particular case, my lord, at page 113, my lord, the dates are given.
Yes.
Page 113. My lord, clause 3. Tender important dates.
Yes.
My lord, e-tender publishing date, start date for downloading of e-tender, pre-bid meeting, closing date and time of online tender submission, technical price, bid both.
Yes.
So, this tender closed on 18th of August.
Yes.
Now, if we, my lord, calculate, my lord, 6 months therefrom, my lord, it comes to February, my lord. So, by February, these rates, my lord,
invalid.
Became invalid. On and after.
Unless there is
of course, by
something to show
mutual,
that
yes,
there
my
is a
lord,
mutual.
which did not take place, my lord.
I will clarify, madam.
Let him place his perspection in the matter. Yes.
So, and this, my lord, has happened on 4th of May. They issued LOIs on 4th of May.
Yes.
So, on the face of it, my lord, those are invalid rates.
All right. All right.
My lord, maybe the other points, my lord, can be taken up later on.
All right. Yes.
Now, my lord, first of all, my lord, kindly see, my lord, on the first day.
You are appearing for?
For, my lord, for BPCL, my lord.
For?
For BPCL, my lord. For respond number.
BPCL. Okay. Yes.
Now, 225, my lord. Look, first of all, my lord, kindly see whether this petition is maintainable. My lord.
Yes.
First of all, see, my lord, whether this petition is maintainable or not, my lord. Because of who approached this court, but this society has approached, my lord. And the tender has been submitted by the bidder individually, my lord. They are not agreed, my lord.
Yes.
And kindly see page 32 of the affidavit.
Page?
32, my lord.
Yes.
It was signed on 9th of April 2024, my lord. And in the next page, my lord, 33, my lord. This is the registration certificate, my lord. It is valid up to 29/3/2024, my lord. It is forced, my lord.
March.
Yes, my lord. So
Yes.
it does not have any legal character, my lord, about we cannot say, my lord, it is a judicial person also, my lord.
Yes. Mr. Goswami?
But these are ongoing exercises, my
No,
lord.
but whether you have renewed your certificate or not?
We have already applied for extension.
It has not yet been granted.
Not.
Now, but in Hostatel, for technical issue, my lord, the petition number 2, my lord, he claimed himself in page 3, my lord, as a president.
Yes.
And in affidavit, my lord, page 32, he claimed himself as secretary, my lord. Whether, my lord, they...
No, here also, he says secretary.
No, my lord, in my Parima is president, my lord.
You come to page 3.
Page 3, my lord,
Represented by Secretary Shri Sanjay Vaishnav. Anyway, in the court's copy, it's corrected.
My lord, it was possibly, I'm sorry, my lord.
Junior to
Yes, ma'am.
correct that.
My lord.
All right. Yes. Anything?
Now, my lord, can you see page para 1, my lord?
Yes.
Page 5, my lord.
Yes.
That the petition number 1 is a society registered under Society Registration Act 1860. In the instance, the petition number 2 is the secretary of the Petitioner Society of Sanjay Vaishya has been authorized to represent the petitioner before this honorable court. And though no bylaw has been annexed, my lord, whether he has been authorized, whether he has singly, my lord, authorized to present this, pursue this case, my lord, without having the bylaw, my lord, in view of the Section 6 of the Society Registration Act, my lord. It's not maintainable, my lord.
All right.
And I am relaying the Meghalaya Wine Society, my lord.
With that
Yes.
suggestion.
2010, 5 years. Paragraph 10, paragraph 9.
Yes, para
Paragraph 9, 10.
11, 16.
Yes, my lord. Oh, my lord, I've gone through it, my lord. My lord, paragraph 9, my lord.
Yes.
The meaning of locality in new so-and-so is given a right to appear in the court or to be...
Paragraph 9.
In my paragraph 9, is that from the meaning of locality?
Here, para 9 is this court.
Can I get them?
You have taken print from Supreme today.
This one.
So, yes.
The meaning of locality in so-and-so is given a right to appear in the court or to be heard on any question in case of Mohan Chaudhary versus Chief Commissioner Tripura so-and-so when the issue of locality came to 4 point before the Supreme Court. Chief Justice Sinha was observed as under, in order that the court may investigate the validity of a particular ordinance or to act legislature, the person moving the court should have a locality. If he has no locality to move the court will refuse to entertain his petition, questioning the virus of the particular legislation. In view of the precedent order passed under the provision of Article 359(1) of Constitution, the petitioner has lost his locality to move the court during the period of emergency. Now the question before us whether the petitioner Meghalaya Wine Dealer Association can assume the character of either a juristic person or legal person without registration and can bring the repeating challenge in the virus of the amendment and new rules. Meghalaya Wine Dealer Association is an association of the licensee who obtains such license for running liquor business in the state of Meghalaya. Each individual license holder, if aggrieved by an action of the government or the respondent authorities, can bring an action under Article 226 of the Constitution. But individual license holder cannot file repetition for each and every license holder unless they form an association and such association is registered. When the
association was not registered.
Yes, my lord. It's Spanish Sports, my lord.
In this case, it is registered.
But it is Spanish Sports, my lord.
Expired.
Yes, my lord.
Now, whether that will have any bearing? Yes. What did Mr. Gogoi say?
Yes. He does a helping hand to me, my lord.
Rangapara Development Society, not registration, but on the day of the moving of the writ, it has to be, the registration has to be valid.
Where is that judgment?
I have it, my lord.
Give it.
My lord.
Try and give it to my court master.
My lord, I'm giving it.
Yes.
My lord, can I, my lord, rise, my lord?
Oh, I'll just take a 5 minutes break. You are and you have encroached.
No, my lordship. From since pre-independent days, my lordship, from our days of our ancestors, my lordship, we were there, my lord.
You have constructed and you have been staying.
Yes, my lord. Since pre-independent days, time immemorial, because we.
What is the government's stand?
These are PRFs, notified PRF. And in the meantime, this honorable court, my lord, or court in the benches held, my lords, they don't have any right to settle or claim PRF lands or reserve for the claims, my lords.
So these are admittedly PRF land.
Yes, ma'am.
As per 31, that you are relying as also it is clear.
Yes, my lord, PRF, my lordship. My lordship, kindly peruse clause 6, my lordship, of the relevant Assam Forest Regulation 1891, my lordship. As per the regulation, my
Mr.
lordship.
Gogoi, have you given a copy of this order to the petitioner? Give him.
My lordship. Clause 6, my lordship, may be seen. At least our claims, our statement should be recorded, and our claims and objections should be disposed of, my lordship. After, there is a requirement that, my lordship, within 30 days, the forest settlement officer
Lordship is holding the number of petitioners there were 535 others. I have just figured out
This one?
Yes. Lordship will see the 535 others. There was also a claim that the large number of petitioners are dependent, so and so that the court refused to interfere.
My lordship, our case, I have not gone through this order, my lordship. I don't know whether this is covered by our case or not, my lordship. I am relying on the act, my lordship.
You just have a look at that coordinate decision, bench decision.
My lordship, this is my lordship very much.
This petition has
wherein
been...
notice was given to the general who have illegally occupied the land.
That's correct, but you
But
see...
we have illegally occupied the land, my lordship. That is the point, my lordship.
You see, even
they should
here...
first say that we have illegally occupied
Correct,
the land.
but you kindly read the entire order. Read paragraph 4. It has been disposed of with the direction that if the petitioners duly file their respective applications
Yes, ma'am.
seeking allotment of land, the district commissioner shall duly consider such applications within the purview of the land policy 2019.
Yes, ma'am.
So similarly, I can dispose of this petition. It will be in your benefit.
Yes, my lord.
If you are
But-
agreeable,
but-
I'll pass a similar order. The coordinate bench has already considered the same argument that you are making. Because admittedly, page 31 indicates that these are PRF land.
PRF land.
Isn't it?
Yes, my lord.
And there is, and on that basis, notice has been given as you taking you have been illegally occupying it. So
Yes.
you make an individual application. Your
We
case
are-
shall be considered.
Our case is slightly different that we are not illegally occupying. Let that.
No, that is your contention,
Yes,
Mr. Counsel.
Yes,
The forest is saying you are illegally. How will this court decide that disputed question?
Yes, my lord. Let
In
them
226?
decide, my lordship. Let them decide our.
So
fate,
let the district commissioner decide that
yes, my
issue.
lordship. That is my lord. And in the meantime, some protection, my lordship. because-
No, what protection?
And there is an interim order also, my lordship. We are staying there also. Interim protection is there, my lordship.
Mr. Gogoi, only thing I have not understood is para 3. Why is it saying, referring to the revenue lens?
Well, in that case, there was a dispute. The petitioner raised a dispute that no, I am occupying revenue. So due to that fact, the Honorable Court said that revenue also has a power to evict if you are illegal, but revenue must confine itself to revenue land, forest will confine itself to forest land.
But here they have been...
These are forest lands.
These are forest land. Therefore, the district commissioner, if applications are passed, can be
Yes,
considered.
But forest also must be taken into coordination. Forest department also will.
So applications will be filed before whom?
Forest settlement
Forest
officer.
settlement
Yes,
officer.
So then I will dispose it up in that
forest.
direction.
Yes, my lord.
There's a procedure laid down.
Procedure
Clause
laid down
8.
where?
Clause 8, my
Forest
lordship.
manual, Assam Forest regulations.
Clause 8, my lordship.
Assam Forest Land.
Clause 8, my lordship, may be seen the Assam Forest Regulation 1891, clause 8, my lordship. Inquiry by Forest Settlement Officer.
Yes. So in terms of clause 8, this can be...
Yes, my lordship.
Yes, Mr. Gogoi?
My lords, 8 is to be done.
Yes.
All right, in item 10, Sharmila. Heard Mr. H.I. Chaudhary?
S.B. Lashkar, my lord.
Sorry. Heard Mr.
S.B. Lashkar, my
Your
lord.
name is not reflected in the cause list.
I have filed call of my lord.
This is item number?
10, my lord.
10.
10, my lord.
Heard Mr. So-and-so, Learned Counsel for the petitioner. Stop. Also heard Mr. D. Gogoi, Learned Standing Counsel, Forest Department. And MS S. Borwa, Learned Government Advocate for the State Respondent. Stop. Mr. Gogoi, you said there is some interim order.
They have said,
Yes, my lordship. Interim order, interim production we have.
Which is the interim order? Yes. Here there are only 3 petitioners.
Yes, my lordship. 3 petitioners.
Okay. By filing the instant writ petition, the petitioner is challenging, the petitioners are challenging the notice dated. The notice does not have a date.
No, my lord. Undated, my lord.
Dated nil. Issued by the respondents number 5 and 6. Whereby the petitioners were directed to vacate the land within 31st December 2017. Stop. The case of the petitioner is that the petitioners were living in the subject land from time immemorial by building and by building and constructing houses.
We have cultivated land also weekly.
Along with cultivable land. Stop. By issuing the impugned notice, the Range Forest Officer, Kualpara Forest Range, have alleged that the subject land has been illegally occupying, which is reserved forest land stroke protected reserve forest. This is written protected here. Proposed reserve forest land of the Forest Department. Stop. It further appears that there has been a direction to vacate the land within 31st December 2017. Stop. Against the aforesaid notice, the petitioners who has been staying in the subject land where their ancestors has built and constructed house
and cultivated,
and where they are cultivating cultivating what?
Paddy, different vegetables and
cultivating paddy, etc.
Yes,
has filed the instant writ petition. Stop. It appears that this court, by order dated 2012-2017, while issuing notice, was pleased to grant in the interim that the petitioners should not be dispossessed from their occupied area in the proposed reserve forest. Stop. Heard the parties at length. Stop. It is submitted at the bar that Regulation 8 of the Assam Forest Regulation 1891 provides that the forest settlement officer shall inquire as regards the claims made under section claims made by an affected landowner.
Yes, madam.
Correct, Mr.
Occupants,
What happened, I like to differ, madam. Not only Regulation 8, there is a chapter, madam, which deals with reserve forest. So proclamation has been issued under under 6. Under 6. So, madam, the 7 and 8, it will follow, madam.
Then before 8 you say relevant
Yes.
regulations pertaining to reserved forest of chapter 2 of the Assam Forest Regulation 1891 are reproduced hereunder for ready reference. Clause 6, clause 4 will be required.
My lord has been...
Alright, clause 6, clause 7 and clause 8 to be marked for this. It appears from the aforesaid provision of law that upon notification being published under section 5 proclaiming the subject land as reserved forest, correct?
Proposed reserve, my lord.
The proposed
Yes, my lord.
reserve forest, comma, the forest settlement officer has power under regulation 8 to make an inquiry, comma, if any claim is made under section 6.
My lord.
Stop. Correct?
Yes, my lord.
In the instant case, it appears that the subject land of the petitioners have been proclaimed to be proposed forest reserve lands.
Yes, my lord.
Stop. The petitioner having raised a dispute as regards the nature of the land, comma, the claim of the petitioners is liable, is entitled to be inquired by the forest settlement officer under section 8. Stop. Mr. D. Gogoi, Learned Standing Counsel, Forest Department, fairly concedes to the aforesaid proposition. Stop. Next paragraph. In view of the aforesaid endorsement made by the learned counsels for the parties, comma, this court is of the considered view that this writ petition can be disposed of with a direction to the petitioners to file respective application before the jurisdictional forest settlement officer within and as and when such application is made before the forest settlement officer, comma, the same shall be considered within the purview of the land policy 2019.
No, Malad, this is a separate, total
So
separate.
then,
1891.
then shall be considered in accordance with law within a period of three months from the date of receipt of certified copy of the order. From the date of receipt of the application. Okay? Stop. With the above observation and direction, the instant writ petition stand disposed of. And just I got detail that needless to clarify that if such application is filed within a period of 15 days from today, comma, the interim order passed by order dated 20/12/2017 shall continue till disposal of the application by the jurisdictional forest settlement officer. Stop.
But the interim order also contains a clause that we shall be at liberty to suppose.
Yes, I have seen that.
Yes. The concluding part.
Yes, that liberty. Further, it is made clear that the liberty granted by this court by order dated 20/12/17 as regards the authorities to invite claims and objections under section 6 of the forest regulation and complete the process for proclamation of the reserve forest shall no, you say that the forest authorities shall be at liberty as granted earlier by this court by order dated so and so to invite claims. To invite claims and objections under section 6 of the forest regulation and complete the process for proclamation of the reserve. Stop.
My lord, small addition, my lord. Two impugn orders, notices, my lord. Two impugn notices, my lord.
Two impugn notices?
Yes, my lord. One impugn notice your lordship has stated, my lordship.
31, and the other one is at?
My lordship, that is 34 and 35.
The details.
One is Lakhipur Forest Range.
And one is Gwalpara?
And one is Gwalpara.
Okay, impugn details to apni page 20 pai jabo. Duta ase de. Gwalpara or Lakhipur. Then underline kori disu. 30 and 31.
Yes.
Highly obliged. Yes.
Standing item number 18.
My lord, by this petition I have challenged an order in review by the revenue authority.
Partition of property.
Partition of property or review order, my lord. Review order. Because this revenue authorities have no power to enter in a review petition, my lord. Here what happened, my lord? Against an order of the circle officer, they filed an appeal before the additional deputy commissioner, my lord. Deputy commissioner. And that matter was heard by the additional deputy commissioner, it was rejected. My lord, if your lordship comes to my lord, page 18, my lord, answer 5.
Mr. Agarwal, you are appearing for?
Number 5.
GA is also there. Yes.
They preferred an appeal, my lord, against the order of the circle officer. Page 18. This is the appeal, my lord.
Yes.
Now, my lord,
appeal.
And in this, my lord, then ultimately, my lord, page 23, my lord, page 23 is the final order in this appeal, my lord.
Yes.
By which, my lord, this appeal has been rejected.
Yes.
The appeal, my lord, this is the entire order I am not reading, just, my lord, because my main crux is, my lord, review. And so, ultimately, your lordship find, my lord, he has considered everything and ultimately at page 28, my lord, under the circumstances, the appeal is hereby dismissed. Original partition case is sent back to Circle Officer Tinsukia Revenue Circle. And it was directed to grant partition in favor of the respondents as in the apply bar. So this has been rejected, my lord. Now, they filed a review before the Deputy Commissioner. This was passed by additional Deputy Commissioner. Now,
just one second, Mr. Avila.
They filed a review at page 29, my lord. There is no power of review, my lord. That must be
This order is filed under review.
Yes.
This order that you're.
No, that was in the appeal.
That was the revision appeal, correct?
Appeal.
Revision appeal.
Appeal. That, my lord, order has been, against this order, they filed a review.
Against the. This is a revenue appeal.
Revenue appeal.
So, filed under 147.
Yes.
Now,
147.
Against the order passed in this appeal, a review has been filed.
Yes. Now they file a review petition, and the Deputy Commissioner, my lord.
Where is that review application?
At page 29. It was filed before the Deputy Commissioner. Additional Deputy Commissioner disposed of the appeal, dismissed the appeal. Now, he has filed this application. Your lordship will find, my lord, that
is there a review power?
No power, my lord.
Then how review?
That is the main question, my lord.
And you are challenging that order by which this.
They have to prepare
order
an appeal before the Revenue Board, my lord.
Review is a statutory. It has to be provided by the statute.
My lord, the Supreme Court judgment.
So many decisions on that. Unless statute provides, review will not lie.
No, not lie.
It's a creation of statute.
Yes. Paragraph.
Is that the only point involved in this?
They can file an appeal before the Revenue Board, my lord, against the order of the additional.
What is the review that they have sought? Is it a
that order of the additional Deputy Commissioner?
On what ground? Is it just arithmetical or grammatical correction, or it's a review?
On merit.
Where is that? What is the review that they have sought?
That page 29, my lord.
Prayer is at page.
Prayer is at page 35.
Page 35?
Yes.
Yes.
So, the entire order is to be modified, my lord.
Review and modify.
Yes. Now, what happened, my lord?
Now, the order passed in this?
Review, my lord. If you also see the Deputy Commissioner, my lord, forwarded it to the Additional Deputy Commissioner, then page 42, my lord.
Yes.
This stay order was passed by the Deputy Commissioner. Then it was forwarded to the Additional Deputy Commissioner. The final order has been passed as Lecture 12, my lord.
Page 49.
Page 49.
Yes.
Here, my lord, the peculiar order, if you also see the opposite portion, my lord.
Yes.
Two paragraphs, page 50. I have perused the records, including your draft CITA and other records, primarily summed up is that both the parties admitted property being ancestral property is the settled order mutation does not confine title. Only the convenience of paying the land revenue. Hence, the primacy case in this court dispute decided first in the respect title over which this court has got no jurisdiction can only be decided by civil court, the competent jurisdiction. Under circumstances, stay order passed by this court.
What kind of an order is this? They have made the interim order absolute.
Interim order passed in the earlier appeal.
That is made absolute.
How they can do it, my lord? That appeal has been dismissed by the ADC.
And that also in the guise of a review power.
Review power. This is the, my lord. They can prepare an appeal before the Revenue Board against the.
Which is the provision for appeal?
Yes, 147. Section 147, my lord.
Section 147 of the
Land Revenue Regulation.
Land Revenue. So regulation 147 or section 147?
Section. Regulation that whatever you says section, my lord.
Yes. Yes.
My lord, appeal shall lie under the regulation as follows to the board from the orders, original or appellate order passed by Deputy Commissioner, Settlement Officer, Survey Officer. So it is passed by the additional Deputy Commissioner deputy.
Okay.
So appeal lie, my lord, against this one. So no review power is there.
Mr. Agarwal? I'll come back to Mr. Sahiwala if need be, but otherwise, his only argument.
Your Lordship will kindly see the power of review is not there. I'm not saying that power of review is there.
So it is admittedly a review had been filed against that order.
What was review? My entire demand is the application. But that I have not heard and the order was passed. When we approach the application, we say that let it be heard. Again. Matter was again heard and ultimately decided, and it was found that since there was a dispute between the parties which cannot be resolved by the revenue authority, Section 100 says that the parties will be relegated to the civil court. Let them go and the matter will be decided. Because the question arises for consideration whether the other sisters who were not before the circle officer can be deprived of and all that, and they say that they are also entitled to the share of the property. And only mutation will not concern any title and interest on the property. The property
That is on, these are on merit, Mr. Agarwal.
No, I'm saying on the Lordship. Your Lordship will kindly see this.
See, because otherwise, since you are, we'll go to Supreme Court later on, but first and foremost, let us be clear on the facts. It appears that a revenue appeal has been filed by you, which has been disposed of, correct? Against that, an appeal provision lies. You have not gone under that provision. Instead, you filed an application for reviewing that order, correct? Now, when the word is review, and in that application, if an order is passed, which is under challenge, first and foremost, this court will have to see whether the power of review exists or not, correct? Admittedly, that power is not there in the statute. If it is not there in the statute, then how can this order be reviewed? Then this order is bad in law. Lily Thomas and so many decisions of the Apex Court, I don't think there is any quarrel to that proposition. Now you are trying to make a submission that your appeal was not heard, it was not heard on merit.
And we are not heard on merit.
Correct. This is what you are trying to say, and therefore it was sent back. Now, what prevented you from filing an appeal when the statute provided an appeal?
So, Your Lordship will kindly see where the order is. Passing that order is wrong or not, Your Lordship will definitely decide that.
No, passing of which order?
That order for reviewing, my lord. Whatever it is, no order was passed on review and all that, my lord.
That is immaterial, but that order is passed in your application for review, correct?
That's true, my lord.
Now, in that application, under which provision of law, it could have been exercised, these things will ultimately have to be answered. Otherwise, a wrong precedent may be laid down, isn't it? Because it's a settled law that review has to be provided under the statute. And most importantly, you had the right for appeal. If that is your grievance, that you have not been heard on merit, what prevented you from filing an appeal? You could have filed an appeal. In the appeal, it could have been remanded back. That could have been done, but that was not done. Now, by filing a review application where this order has been passed, and this order, when is put into challenge, this court will have to see the legality of the order, whether this could have been done in the guise of a review. That is the only limited question. I don't think we need to travel to the merit or anything.
I'm not taking on Lordship on merit. Lordship will kindly consider one aspect of the matter.
Yes.
This is the Apex Court. And several decisions say review are up to time. Review on merit and procedurally. Now, my submission will be in this case that the Deputy Commissioner has not decided, the Deputy Commissioner has reviewed the Deputy Commissioner has passed the order that since he has not been heard, kindly he may be heard. No order was on merit was passed, no order on merit was passed. Therefore, the matter was heard and ultimately the matter was decided and order was passed thereon by the additional Deputy Commissioner. Now, my submission will be that that particular order which was passed by the Deputy Commissioner, in case 42 Act, already shown to my lord, it will be a procedural review. It will not be a review. And second aspect of the matter, most important, my lord will kindly see, this challenging that order, a writ petition was filed before this honorable. So they have withdrawn that. Your Lordship will kindly see that I have enhanced
Challenging what?
Challenging the order of review.
Yes.
That this petition was filed before this honorable court.
Yes.
You know, I'll take to my lord.
Again, that is the same order which is under challenge here.
Yes, no, that order will not, my submission, that order cannot be challenged because they have already withdrawn. They say that if fresh cause of action arises, we will file a separate petition.
They file a separate petition.
Fresh cause of action arises by the final order. I mean, my submission.
Oh, where is that order?
Yes, I'll answer. In my just give me 1 minute.
Page 49. Page 49 for the petition.
Huh?
Page 49 for the petition.
I don't think it is annexed.
No, yes, yes. Have made a statement. I made a statement in this regard in my affidavit at page 15.
No, but where is that order? Let's see the order. The order will clarify everything. Affidavit in opposition by R5.
R5.
Paragraph?
Paragraph 15.
Yes. Yes.
That the statement made in paragraph 20 of the petition, in matters of record, I do not admit I am skipping that line number 6.
In view of own admission.
In view of own admission of the petitioners, or in paragraph 20, they have made a statement in this regard. So they have enacted. They have enacted. Without your lordship will find that order at without an except 10 in the rate petition.
No, in Mr. Agarwal, just 1 second. Mr. Sahewala.
Yes.
What was under challenge in WPC 3262? Yes.
That against the order dated 26/8/2015.
This is the review order.
That order, that is Deputy Commissioner page 42 order that Deputy Commissioner has passed. By the decision, the petitioners have already filed WPC so which has been withdrawn on 1/6.
Where is Annexure 10?
Annexure 10 at page 44.
Well, that was the interim order. That was the interim order.
Not interim order. Page 45 is the relevant portion.
But with liberty to reapproach.
No, my lord will kindly see. Therefore, the trace for withdrawal of the case is liberty to reapproach. If the trace cause of action becomes
the case is disposed of accordingly as not pressed. Accordingly is there. He had prayed for liberty.
No, he has prayed for liberty if trace cause of action. My submission would be without trace cause of action.
All right. Noted.
That order was against my lord Annexure 9, page 42. That read petition was. That was a
Annexure 9 at page 40?
44, 42.
42.
My lord, this was the interim order of the Deputy Commissioner.
And because in the meantime the final order has been passed.
Yes, final order has been passed.
That is why, my lord, we have withdrawn that.
All right. All right. Yes, any more submission, Mr. Agarwal?
Yes, the review.
Procedural.
Procedural and melody. I would like to make my submission from that. The most important aspect of the matter, though it is not connected with review, they filed the partition application before the circle officer.
We are not going into all that, Mr. Agarwal. We are making it clear. Let us first be. You may develop the point that you want to argue as regards procedural and that you may develop. Mr. Sahiwala, I suppose you are carrying those decisions on review. If not, you can ask your junior to just have one or two decisions. I think Lily Thomas is also one.
Yes, but I have given one, my lord, that Kala Bharti advertising, paragraph 12 to 14. What is it?
12 and?
12 to 14, paragraph
12 to 14?
Yes. There, my lord, the other distance has been cited.
Yes. Can you please ask your junior to also check the citation for Lily Thomas? I think it is 1999 probably. Yes. Lily Thomas.
I'm not disputing that. I'm not saying my argument.
You are trying to develop another. I've understood. You are saying if it is not on the merit and procedural, probably there you are saying review can be.
The inherent power is there.
Yes. From what is this, Devi? This is in that 3496 writ petition.
I have given
What is this?
Yes. Bunch of the decisions which I am relying. They must have a decision.
But now show me that procedural part.
I'll come. So we will kindly see.
First you are relying 1980.
80 treeless bench.
Yes.
There are 6 percent.
Yes.
We are of the opinion that tribunal has the power to pass the in order as the thought fit in the interest of justice. It is true that there is no express provision in the Act or the rules and thereunder giving the tribunal jurisdiction to do so. But it is well-known rule of statutory construction that a tribunal or body should be considered to be endowed with ancillary or incidental powers which are necessary to discharge its function effectively for the purpose of doing justice to the party. In case of this nature, we have to view that tribunals could have considered as invested with such incidental necessary power unless there is any indication in the statute to the contrary. We do not find any such statutory prohibition. On the other hand, there are indications to the contrary. There are 8. The object of giving such wide power to mitigate the rigor of technicalities of law for achieving the object of effective investigation and settlement of judicial disputes, and thus ensuring industrial peace and harmony. The discretion thus conferred on the authority to define the procedure as they may think. However, is subject to the rules made by the appropriate government in this behalf. Nevertheless, all these authorities being quasi-judicial in nature, objectively determining matter refer to them, have to exercise their discretion in the judicial matter without caprice and according to the general principles of law and rule of natural justice.
No, but these are relating to this part, isn't it? Under clause A to C. Under in para 7.
Para 17.
Para?
I'll come to para 13 now. We are unable to appreciate the contention that merely because the ex parte award was passed on the statement of the manager of the defendant, the order setting aside the ex parte award in fact amounts to review. The decision in Patel, Nursing so and so and so and so in distribution. It is an authority for the proposition that power of review is not an inherent power. In the other case, my lord, it was 1971. It must be conferred either specifically or by necessary implication. As my lord is saying, that there must be some statutory power. Subsection 1 and 3 of section 11 of the Act themselves make a distinction between procedure and powers of the tribunal under the Act. When the procedure is left to be devised by the tribunal to suit carrying on its function under the Act, the power of civil court conferred under it are clearly defined. The question whether a party must be heard before it proceeds against one of the procedures and not a power in the sense in which the words are used in section 11. The answer to the question is therefore to be found and not in subsection C. Furthermore, the different consideration arises.
So therefore, initially this court was putting this question: what is the modification or review that was sought in that application?
Can you see my entire demand is this? Though prayer is that prayer, my Lord, has that thing,
That prayer is on merit, isn't it?
Entire demand, my Lord, is that on that day when the order was passed, my Lord, we were not hired. And my Lord, for that, my Lord, I have made a statement. Certified copy I have obtained.
No, but if you see your application is not.
Application is for modification.
Correct.
But my Lord, the ground was there that I have not been hired. Now, because of that, my Lord, the Deputy Commissioner passed on the body that hear him once again. Hear him, that was the order was passed. So Deputy Commissioner did not pass anything on merit, my Lord. My submission is that. Deputy Commissioner did not decide the case on merit. He said that their grievance is that he has not been hired, can you hear them? That was the order. The expression review is used in two distinct sense, namely one, a procedural review which is either inherent or implied in a court or tribunal to set aside a.
So what is the procedural defect in your case, Mr. Agarwal?
I was not heard, my Lord.
Why not heard, Mr. Agarwal?
I was not heard on that.
No, but why?
But that was not a date fix, that's why I am saying, my Lord.
That was not a date fix.
Yes, not a date fix.
No,
My Lord,
please clarify those facts. That
have-
what led to that ex parte?
Yes.
Where are those facts?
I am mistaken. My Lord, you will kindly see.
But will that be a procedural defect? Anyway, let me see the facts first. If need be, I'll come back to this decision, but I have understood the point that you're trying to draw home.
Yes,
So that is why the facts would also be required to be seen. Correct.
I am not saying that facts should not be. My Lord, may I take to my Lord. There are 13 pages of my video.
Para?
13.
You have extracted the entire order sheet. The order sheet is extracted.
I have accepted the order sheet. I'll come.
Yes.
Not required to go into the entire.
Yes, para 13.
The sequence of events that I have stated.
Yes, please.
Yes. Now, my Lord, will kindly see page 13.
Yes.
Order passed by the agency calling for original CITA, also asking the Circle Office to submit a physical status report of the rain in question and fixing the date on ITNA. Now, Hajra filed by the petitioners, 16-6, order passed by the direct agency to the effect that seeing the report as called for by the error and also heard the parties and having gone through the.
Which one are you reading?
Page 14. Page 14. 13 I have read that 1-6. In my opinion, it is no question.
No, this sequence of events are there.
Yes, Lord, you can skip this.
Now you have come to internal page 14.
Page 13.
Huh?
Page 13 first.
Page 13, yes.
Down below, my Lord.
Yes.
1-6.
15.
1-6-15. Order passed by the letter agency calling for original CITA, also asking the Circle Office to submit a physical status report of the rain in question and fixing the next date on 16-6. So on that 1-6, my Lord, 16-6 was the date fix. Now, on 16-6, my Lord, both the sides filed the Hajira. Hajira filed by the petitioner. Order passed by the letter agency to the effect. Since the report as called for by the NM and also heard the parties and having gone through the draft CITA, I see no ground in calling for the report from the Circle Office in CPR to ask both the parties to file any documents if they wish fix 6-7. Now, this date 6-7, I have later on explained that date 6-7 was not fixed. 16.7 was fixed. 8.67 was not fixed, 16.7 was fixed. Also from this document.
No, but then you see, these are not, these are again grounds for which you could have filed an appeal. These are not procedural defects. Procedural defect, if you may correct me if this court is wrong, that would indicate to some procedural lapses for which unnecessarily, just because the review power is not there, it would not be fair to say that the court will not have that inherent power to correct, because no arguments would be required. It is just a simple procedural defect, something which on the face of it manifestly shows that it relates only to a procedure. Here it is not about procedure. Here you are saying that it was fixed in your presence. Now you are saying that that is not the date, it's a different date. Then these are illegalities. This will have to be, these are issues which probably you could have taken in appeal. Now, in the guise of a review, you file an application for review. In that order, after hearing both the parties, the court has remanded the matter back in exercise of which power? Review power. When that review power is not available under the statute, how could have that power been exercised? That is why the order appears to be absolutely without jurisdiction. This is what this court is thinking. We may come back at 2. You think over it, because it doesn't appear. There is no proposition to the decisions that you are trying to show, but those are on procedural part, right? Because those decisions has to be understood in the context of each case. Correct, it's contextual. Decisions are always contextual. And I don't think there can be any dispute to that procedure part also. I'm sure Mr. Saivela will also agree that in a given case where on the face of it no arguments required and it is just a matter of a procedure, then the court inherently will. That's why I was asking if sometime arithmetical or grammatical corrections.
Those are will file in the CPC and other things, the provisions are there.
Yes, but the tribunals, say for instance here, they do not have those powers.
Those provisions are not there.
Correct. The spirit will.
And review power is also not there. I am not saying that the power of review.
No, I appreciate it. You are trying to say that in this case, because you were developing a case where you were impressing this court that this is a procedural defect. But my query to you is, after being shown, that how can this be a procedural defect? This is about, isn't it? At 2. All right. Heard Mr. B.D. Goswami, learned counsel for the petitioner. Also heard Mr. S. Borthakur, learned DYSGI. You are for 225. Mr. S. Borthakur for? 225. Respondent number 225, and Mr. S. Roy. SS Roy of DYSGI, learned DYSGI. Stop. CGC. Then this is wrongly reflected in the cause list.
No.
That is how. Alright, learned FCGC for Mr. SS Roy. Mr. I think it will, instead of rejecting the interim or not saying anything, let me simply adjourn the case. That would be appropriate.
Yes, so
otherwise, it will cause prejudice to you only. It appears, don't say it appears. Mr. S. Borthakur, learned counsel for respondent number 2256, 1 week time to file the affidavit in opposition in the matter. Stop. Prayer is not opposed. It has come to the notice of the court that LOI in context, LOI in pertaining to the subject tender has already been issued on 4/5/2024 in respect of
carriage of
to the
members of the
members to the selected members of the petitioner association. Stop. Considering the challenge made in this writ petition, comma, the said LOI shall remain subject to the outcome of the writ petition.
Yes,
stop. List this matter after. You want a date?
My lord, yes, definitely. No, no.
On 17, madam?
17/5/2024.
It will be done 21, madam.
Let it be on 17, my lord, so that I get an opportunity, my lord, thereafter, if they file it before that, to fine.
Alright.
Otherwise,
I am returning all your papers, including that Meghalaya case and this email, everything. You place everything by way of an affidavit. And also returning your papers. Alright then.
My lord.